6 months later. As you can see, there were many public recommendations and face-to-face conversation about how it should be shaped and how they should establish such a body. And at the beginning, Mark Zuckerberg in different interviews called that it is like a quasi-Supreme Court. So basically what they had in mind, that they need some kind of a judicial body. Of course, they cannot be a judicial body because they don't have the they don't have the idea of having the normative power like state does. They don't have the sovereignty, therefore they can be judicial. But as it was shaped and as the decisions and the charter is built upon, it has real common values and establishment, like we have, for example, in the centralized or the decentralized constitutional systems, both in the Europe or in the United States. So it was a new idea how we should regulate and actually limit freedom of speech. So later on in 2019, a final version of the charter was published. Of course, amendments were also made after that. And the FOB was open to business in late 2020 in October. So this is how all started. And now, since I would like to focus on one particular issue right now with a hint of an Indian case, because you have one case concerning India, and I would like to show you that as well. But now I would like to focus on hate speech and how the limitation of hate speech and limitation of freedom of speech is actually on in the decisions of the Facebook Oversight Board so far, or how it was developed. I start with the beginning. I named the cases in order to easier to refer to, so I called it the Burmese Muslim case. So the Burmese Muslim case was about a situation when there was a content on Facebook when a Kurdish toddler was drowned in the Mediterranean Sea, and there was a post and a text that there is something wrong with Muslims psychologically. So what's said, according to Facebook, that they have a community standards and they have three years, we can call like three groups or three categories of hate speech, and they define quite extensively, I wouldn't say all of transparent and all of these policies are good, but quite extensively, you know that whether your content and whether your speech is considered to be a hate speech according to Facebook or not. So what after happened, then Facebook said that hate speech is an attack based on protected characteristics. So basically it said that they prohibit any generalized statements of inferiority about the mental deficiencies of a people or group of people, especially if those are based on religion. So they said the reason why they wanted to limit this content and actually remove it from Facebook is because it is a demeaning expression concerning the Muslims and especially the Muslim people. But there was some contextual issues which in the general appeal process in the Facebook, because what happened in Facebook, I'm sorry, is like you have a content, you posted something online, and then it is removed because it is reported by someone else. And then you can appeal within the Facebook, and you're going to have like content moderation, whether by artificial intelligence or human moderation. But after that, the process is final and you couldn't do nothing before. But now you can appeal this to the Facebook Oversight Board, and they might take your case if they think it's suit and meet the requirements. And this is how it works. So this case, all of the cases I present to you went through three processes, but the Indian case is special in that scenario as well, in that aspect. So what happened when the Oversight Board had the case, they said, okay, we need translators and we need to understand the context, how it was said. And they said, okay, maybe, so the translators of Facebook said that the meaning of this text is basically that those male Muslims have something wrong in their mindset who actually took the picture or let the Kurdish toddler drown in the Mediterranean Sea. So it is more likely just a discussion about what kind of people led to die a toddler. And then maybe these terms showed intolerance, but they were not derogatory or violent. Therefore, they do not be considered as hate speech. Therefore, the content should not have been removed. And that was their idea, according to community standards. And then the Facebook went further and they said, okay, let's check the Facebook Oversight Board values. And you should know that basically the Facebook has like 4 values. Voice, which is the freedom of expression. They want to provide a platform for everyone to express their opinions. Authenticity, so do not have like fake news on the portal and try to be as authentic as possible. Privacy, to protect the rights of others and the private sphere of yourself and for the users. And last but not least, safety. Usually I would say that they also include dignity as a value. So I would say that it is more likely 5 than 4. And if we check the cases, usually safety and dignity together versus the voice. So it is like the situation which always arises when we talk about freedom of speech. When is the limit of my speech and when it should be limited in order to protect the rights of others, especially their safety, their well-being, the non-discrimination clause. So all of these ideas are basically together. And in this Burmese case, according to Facebook values, they said that the content did not pose any risk to safety, which would justify limiting the freedom of speech, so limiting the voice, as it is the buzzword for freedom of speech in this FOB context. But more interestingly, and which I would focus in my presentation, is the human rights standards, especially the International Covenant on Civil and Political Rights, which is like a quite old standard in 1966 when it was first adopted. And they said that so it was written to me that I am muted. Can you hear me now? Kushal, can you hear me? Because I was muted for, yeah, okay, I'm sorry. Okay, so if you go further, then, so human rights standard, how it is into this mix is basically from the United Nations Guiding Principle on Business and Human Rights. I can refer to as UNGPs, because endorsed by the UN Human Rights Council, they said that they established the United Nations a voluntary framework for the human rights responsibilities of private businesses. And be very careful with this word, human rights responsibility. I will go back to it later, why I found it very important. So what happened in this case is that there was no foreseeable basic danger that any injury, imminent danger is going to happen. Therefore, they said that the human rights standards are not met. Here, it is the first case on hate speech in the Facebook Oversight Board case law. And as you read the case, you can see that it's quite short, even the decision. And also the idea of limitation of freedom of speech based upon the ICCPR is really not worked out. So they just said that, okay, we checked a few ideas and we think that content should be removed. So that was all the decision, and they restored the content. What Katterman and Tiedecker, German scientists, wrote about that basically they analyzed and they, I would say that revealed that there is a certain self-constitutionalizing functions. So basically what they said, according to Zuckerberg, it should be like a quasi-judicial body. Of course, later on, probably for marketing purposes, they said that it is just a committee which decides and help to promote freedom of speech. But at the beginning, if you see the early interviews, then you can see that he compared it to the Supreme Court of the United States. And then the Facebook is building up a judicial process. Of course, it's not a judicial process, but alike, I would say that. And they say that their decision is final, and Facebook is bound to execute the decision within 7 days. And of course, they can have like policy recommendations. So if you compare, for example, to the Hungarian Constitutional Court, which can really decide whether a freedom of speech restriction is a necessary and proportional restriction and limitation of freedom of speech, and they can annul a decision and really say that it is not in conformity with the constitutional the fundamental law of Hungary. And also they can sometimes say that there was a rectification by omission, so basically something is not done by the national legislation, and they can recommend what they should do. Basically, it's like the policy recommendation of the Facebook Oversight Board. And if also you said how the presidential system, it is written in the charter of the FOB that they need to build up a case law, and the cases need to have precedential value. So really the idea, which also you can explore here and reveal, as they want a body which is very similar to the Supreme Court of the United States, the European Court of Human Rights in Strasbourg, or the constitutional courts in a different nations. So the next case, building up this process, is I call it the Romanian case. Basically, there was some play with the words, because they said there was a post about the church, and it was when there was on Karabakh, there was an armed conflict between Armenia and Azerbaijan, and they said that basically so Armenian built Azerbaijan, and all these Azerbaijani people worth nothing because they don't have a culture, etc. Okay, so that was the meaning of the post and the content, and it was quite tough. And also, there was some word with the play with the words, because they referred to like tazik and azik in Russian. And tazik in Russian means like washbowl. So it is very demeaning and dehumanizing word and expression to use. So it was in a public Facebook group when there were like 45,000 views, why there was an armed conflict on between Armenia and Azerbaijan. And according to Facebook community values, it constituted a slur. Slur is basically like, I would say, like, if you incite somebody to violence by your words, then you incite somebody to actually do like imminent unlawful actions. So you really, the timeline is very strict. There is a direct connection between your speech and the unlawful actions. Slur is when, I would say, like, you just inflame somebody, and there is a remote possibility that due to your speech, they might cause unlawful actions, and they can lead back to that. But the distance is a bit remote, not so direct like in incitement, and that is the slur. According to Facebook, they have an internal list of slur terms, and tazik, azik player with such words, it was included. Of course, it was not public. So a user who just posted something, they didn't know that it could be in the list of such slur terms. But no matter what, it considered a slur, so the post was removed. And I think the reason why I would like to tell you these stories as well, because the UN Special Report on Freedom of Expression said that the companies do not have the obligations of governments, but their impact requires to assess same kind of questions. So what, in a hidden way, it is said that governments need to respect freedom of speech, but of course, they need to establish limitations, standards, and tests. On the other hand, companies like Facebook have a lot of online comments, but they are not state territories, so they are not governed by the state. Then they, as a businesses, can decide which is online and not, so they have to deal with the same ideas, but they don't have the same standards. And it happened here, and that's the key element of my presentation. You're gonna see it very soon, that some contents like slur, according to Hungarian constitutional law, is constitutional. So words which constitute slur is protected according to Facebook community values, it's not protected. So the question is, what will happen if me as a Hungarian post something and it is removed? And of course, I can say that Facebook is a company, of course, but we're going to talk about what if Facebook not just a company, but it turned to be a public forum, which is going to happen soon because we have decisions in Germany and the United States as well. And it happened something similar in Hungary as well. So go back to the case of Armenia. So the human rights responsibilities now widely and well established and well funded by the United Nations Guiding Principle and by the United Nations Special Report on Freedom of Expression. So instead of just having a short decision like in the Burmese case before, now they apply for the freedom of speech limitation standards of the ICCPR. And basically, this is the one we use in most of the constitutional systems, I think. Then you need legality. So you need to be clear and accessible rules, which can be widely known for free, that which I must obey to. And there is a legitimate aim, which means that the limitation need to pursue the legitimate aim. And also there need to be something on the other side of the collision of freedom of speech, usually the protecting of rights of others. In this case, in the Armenia, they said that the restriction was widely known and the legitimate aim was to protect equality and non-discrimination. And you need necessity and proportionality as well. And that is always the question, whether if the legality met, if there is a legitimate aim, whether it is necessary to limit freedom of speech, and if it's necessity, was the limitation proportionate. According to the majority, because usually it happens the procedure, then a 5-member panel receive the case, they draft a decision, and the decision go to the full session, and at the full session there are like 40 members, then the majority need to decide the case, and the minority cannot have like a dissenting opinion. They just write in the decision that okay, this is the dissenting opinion of the majority, of the minority, but you don't have like a separated dissenting opinion. So what the majority said, it was proportionate, it was actually a slur, it was in a recent ceasefire after an armed conflict. So it's very important to keep off the Facebook this content. The minority said that it was not proportionate, maybe like a warning sign, or you need to click on it, that I really accept to view this content, maybe, or maybe it should be flagged. So there are other decisions because it is a political discourse about the conflict. And political discourse is widely protected. And the most important protection of freedom of speech is when it concerns political discourse. And if it is chilled, then it's not proportionate. So that was the idea. At the end of the day, the majority said that it's proportionate. It met all the standards of the ICCPR, and they had the human rights responsibility. So they removed the content, and it stayed removed. And now I would like to show you why the slur means and represents a problem, for example, for a Hungarian lawyer. According to the Hungarian constitutional law, we have like 3 decisions built upon each other. So the Constitutional Court of Hungary was established in 1990. And since then, we have 3 decisions, all dealing with criminal code issues and all with the slur, whether incitement or like inflaming expressions should be protected or not. In 1992, the criminal code had a word that there is like degrading expression on national and ethnic minorities. And basically, they said that the criminal code said that it is a slur, but it is just a remote danger to the public peace, a public interest. Therefore, limiting a freedom of speech which constitutes a slur is an unconstitutional decision. It should be protected because no matter of the veracity and the content, it should be protected. So this was the first decision. Then 12 years later, in 2004, there was an amendment to the criminal code when we have like a facts of crime, and he said the incitement to racial hatred, and they wanted to amend with the second paragraph, inflames to hatred, which is basically inflamed to hatred is like you using degrading, demeaning, and dehumanizing speech targeted like usually groups or persons with protected characteristics. So the President of the Republic has the right to submit any of these laws before they adopt it to the Constitutional Court, and this is what happened. And the President of the Republic said that if we allow it, then we would be lowering the threshold of punishability. So this is what I constantly and continuously try to highlight in this presentation. Then slur is not unconstitutional, and it is a protected speech according to the law of the states, especially Hungarian state, and it is not protected by Facebook even if I'm using in Hungary under the Hungarian law, because they said that Facebook is a company, so they are not under the law of Hungary. But we're gonna discuss just a bit later. And then they did not say that the amendments, according to amendment, it did not reach the level of incitement to hatred. So they reinforced their decision in 1992, and therefore slur is protected speech. And 4 years later, again, they tried to amend the criminal code again with a different wording, like it could denigrate a member of a group or damage the human dignity. Again, the President of the Republic had such constitutional issues based upon the two former decisions, and they said that it is at the end of the day, the Constitutional Court reinforced the two previous decisions and said that, okay, the new definition of hate speech is again an immaterial offense, and therefore, since it's too remote, it's again just a slur and it should be protected. Go back to the third case of hate speech in the Facebook Oversight Board decision, which was about a Dutch tradition, the Sinterklaas and the Zwarte Piet, which basically like the Santa Claus and with the helpers, but the Zwarte Piet, I don't know whether you're familiar or not, but basically people are wearing wigs, they black facing or actually painted black, usually just the face, but sometimes their whole body, and they like play with the kids, but according to Dutch experts, it is basically a part of like the systematic discrimination of Black people in the Netherlands. And they said that blackfacing itself is basically like a demeaning and dehumanizing, and also like a recall to the era when African slaves were forced to go to the Netherlands and work there as slaves, and therefore it should not be allowed. But it's a Dutch tradition, and usually it is just to play with the kids. So there is a huge collision whether this right to culture and right to freedom of expression should be protected against discrimination and equality, like non-discrimination and equality. So the past was in a family member, so in a family, between family members, and only like 1,000 views and 50 reactions from there. So it was not like a 45,000 political discussion like the previous hate speech case. And it was in a different category, in category 1, hate speech. And what Facebook said, that the reason why they removed the content, because they expressly included blackfacing in the list. So if you read the community standards, then you can find 301 hate speech policy. And if you read it, then you can say that is blackface. Of course, some people would say that no one would do that. None of the Facebook users, or most of the Facebook users, before they post something, do not make like their legal research and actually finding out that, okay, whether it will fit in the legal framework of freedom of speech according to Facebook community values. It's not really common. But Facebook understand that, and they actually released the video in Dutch a few weeks before the Zwarte Piet and Sinterklaas tradition, and when it happens in the calendar. And they said that of course, in Dutch, it was told that blackfacing is going to be removed, no matter whether it is a family situation or if it's a political discussion. It is discriminatory according to the Facebook values. It's all of the content is going to be removed. But still there were posts. One of them went to the oversight board like this one, and the oversight board said that basically according to their values, the majority said it sustains such a systematic racism in the Netherlands, which they must avoid and eradicate in their country. So such posts must be removed, and no content of blackfacing should be allowed, no matter whether it's a right or culture, because the safety of others and the equality promotion requires such steps. Second of all, the minority said they are not really sure and convinced that such a systematic racism is there in the country. More likely think that if a child is really encouraged to identify him or herself as a Zwarte Piet, so blackfacing, wearing a wig, and feeling that they are basically inferior to the white Sinterklaas, then they can identify and really feel empathy, how bad it should feel. Therefore, it's this tradition regarded to be as positive, and they promote equality instead of basically violating discrimination or violating equality and equality laws. Of course, again, the ICCPR test was applied. According to legality, they said that, yeah, the rule was sufficiently clear. Even a video was released, so in Dutch language, so there was no language barrier at all, and therefore legality is met. The legitimate aim was very clear. First of all, equality and non-discrimination, and second of all, the protection of children, because the Sinterklaas is a tradition when the parents try to entertain their children. So we need to protect the children, especially the Black children, for being exposed to such in a systematic and institutionalized racism and discrimination. But, and usually I don't write huge quotes on slides. I love like a few words and the buzzwords, but I think this is key to understand and see what the special reporter said, because I think that is important in our future. Not just in this conversation, but in the future at all, for freedom of speech scholars and for non-scholars and users as well, because they said that companies may remove hate speech that falls below the threshold of incitement to discrimination or violence, because they're departing from the high standard states must met. So companies must provide explanation of the policy clarified in accordance with human rights standard. So, and now the case is what I would like to mention. We said that a company had a human rights responsibility. What Facebook Oversight Board is doing is what all of the constitutional courts all around the world and Supreme Courts are doing. They have a test. Right now, not the national constitution, because they don't have. They apply the ICCPR because it's a UN document, and the special report of the UN and the United Nations guiding principles said that you have this voluntary framework to do it, we promote it, but you don't need to meet such a high standard as state because you're not a state, so you can remove content, which content should be online and remain online according to your legal system. So the state's normative power allows you to have such a speech. And what happened in this case, there's a case in the United States in the Night First Incorporated versus Trump, when they said that Donald Trump, former president of the United States, has an official Twitter account as a president. And this account itself is public forum, just like a street or just like a square, which means that national law applies not the whole Twitter, not the Trump's personal account, but the official account of the president. And therefore, there is a collision, because if it's a public forum, then national law apply. And what happened in Hungary, there was no case like in the United States. But during the pandemic, our prime minister first introduced all the information and introduced the government decree's contents before it was written in the official gazette. So the first instance, you know, the information, it was the official Facebook profile of the prime minister. So if you see an analogy between them, you can say that, okay, then that is a public forum, which means that Facebook no longer can say that, hey, I can remove your content because I have a human rights responsibility. I'm not the state. I'm just a company. If you don't want my service, don't use it. But from now on, we cannot accept such argument because it might not be true anymore. Because before official gazette, any people in Hungary who have no Facebook or do not like or follow the prime minister, they have a lag, a behind, basically, in the information. And I think that makes it a public forum as well. And in Germany, there were also case law by the NetzDG, like a network act, and about the networking and online environment. And they said that Facebook, they didn't say really just Facebook, they said that the two social media platforms are public communicative spaces, which means that they can no longer hide behind the argument that we are just a company and do not use our service. And at that moment, what UN promotes and what Facebook Oversight is doing regarding slur is against the Constitutional Court jurisprudence, for example, in Hungary. And I think that's an issue. All right, so now back to the blackface case. The last standard which must be met is the necessity and proportionality. And again, as you can see, the majority said it is proportionate because you need to focus on the cumulative harms of the hate speech. So not this particular speech itself weighted on the balance between safety and freedom of expression, but their cumulative harms, which I think it's a very dangerous water to sail on. I would not recommend to go that far. I wouldn't say that any of the courts and lawyers would go that far, but of course the members of the Facebook Oversight boards are not lawyers, or not everyone has legal education, so they might have different ideas about that. And it is the first time that they are citing the Romanian case, so the precedential value of the Romanian case tried to be strengthened and built upon in the blackface case by the Facebook Oversight Board. So what minority said, of course, it's not proportionate because the rule was unduly broad. We know it from the United States, they have the overbreadth doctrine or the vague and overbreadth doctrine. And according to the board minority, it has a chilling effect on freedom of speech. Again, they said that it is the right to culture. It was a post in a family circle. Therefore, why would they do that? And why would it be so bad? They already have their arguments. And now, last but not least, the India case, the case concerning India. It was a very, very, I think, politically sensitive case. To be honest, I am not sure whether I should have this conversation here, but it is the only case when India was concerned. And I saw that it is a politically influenced case, but I just try to focus on that without knowing all of the background in India. So my apologies, I have no intention to hurt anybody. I just try to say the fact in an objective manner. So there was a user who shared a video in Punjabi language and also added some text in the post. And the text was, I quote, "The RSS was threatening to kill Sikhs, I don't know the pronunciation, apologies, and the minority religious group in India, and to repeat the deadly saga of 1984 when Hindu mobs attacked the Sikhs." It was online for 14 days before it was reported that terrorism, that was the reporting, and there was less than 500 views though. Upon the report, such a post was removed by a human moderator, and the user's account was suspended. Of course, just for a period of time, but it was suspended. And what happens when the appeal goes, they said that no, the decision is final by the human moderator, and it goes to the Oversight Board. But when the Oversight Board started to discuss the case in a 5-member panel, the Facebook already acknowledged that it was an error, and they restored the content, and they said that unfortunately it happens that during the COVID, they don't have time for all the human moderators to watch the videos full. It was a 17 minutes video because they have to deal with hundreds and hundreds content, and they sometimes make errors, and they understand that it is a mistake. So they restore the content. They don't think that the case should be reviewed. But the board said, no matter what, they have the right to review the case, even if they don't need to act anything because the content is already a mistake and the mistake is acknowledged. So the Facebook said that even though that the content moderators don't have the time to watch every time the contents, especially if they are long videos, but the account restriction is automatic, which means that the content moderator do not see that at the end of his decision or her decision, your account might be suspended for a fixed period of time. So the Facebook tried to save, which beyond saving, I guess. And then the Facebook Oversight Board analyzed the case, again, building up the ICCPR standards and the Facebook freedom of speech limitations and all of these standards. And they said, okay, we checked the legality, legitimity, and necessity and proportionality test, whether to decide that what should have been done. And what they said in the legality matters that the community standards are not translated into Punjabi, which means that basically, if I'm a user who speaks only that minority language, which is like spoken, I guess, around, as I read, like around 30 million people in your country, neither the Facebook's internal implementation standard were translated into Punjabi. So how should we expect people to know the rules if it's not in their language? That was the idea of the board. Concerning the legitimate aim, they said that we must protect the right to life, security of person, equality and non-discrimination, and that's the aim we pursue. And also, in the necessity and proportionality, they said that dominant platforms should avoid undermining the expressions of minority. And as far as I know, it was during the time of a farmer protest, quite massive one against the reigning government and the prime minister. So it was a time when speech must be heard better than most of the times, if we can say so. And you cannot do that. This is the moment when you basically silence somebody's speech, especially if you silence a minority and their idea. And also, it is a quote from the decision of the Oversight Board. They said that in such regional contexts, arrows can silence minority voices that seek to counter hateful and discriminatory narratives, as in this case. So the board was quite intrigued to make a point in the statement that we understand that you make mistakes, but sometimes you as a huge platform cannot make mistakes because that's your responsibility if you talk so much about human rights responsibility. So the conclusions here, as the Facebook Oversight Board applies the ICCPR standards on the freedom of speech limitation, they are promoted and endorsed by the UNGPs and the UN Special Reporter. So they said that, okay, yes, you should do such an evaluation and weighing the balance between the freedom of speech and other rights. But as we can see, due to the US Public Forum Doctrine, which I mentioned, or the Germany situation, and the Hungary's announcement of the Prime Minister recently in the last 2 years, you cannot really allow to have lower standards for a limitation than the state does. But according to the current situation, you have. But what you are doing, I think, again, is sailing on very dangerous waters in terms of law. And the ultimate question for me, as a researcher, as a lawyer, or as a user of the social media platforms, will be the standard of limitation concerning freedom of speech is decreased. So while I'm using the platforms for the purpose of convenience, where I can reach out to people, or I'm enjoying all of the benefits of such systems, would I really, or should I really sacrifice my freedom of speech? That's the question. And of course, you would think that, okay, this guy should really finish talking, but I just really want to share an idea of mine. Before the metaverse happened, like a year and a half ago, I published this article, an article in Hungarian, when I said that if I check the pieces of the puzzle and I put together, then I think that Facebook is building a digital state. And the first question, am I crazy? Is it true? Can it happen? And then I checked, as a constitutional lawyer, what makes a state a state. You need territory, population, governance, and sovereignty. Okay, what do we have? I said before the metaverse, I said that the Facebook has the online environment, which they rule. So their segments of the platform, including the Instagram, the WhatsApp, and all of these, this is their territory. Population, easy, 2.9 billion users worldwide. What is the governance here? Then I really think what should happen, and I checked some articles, and back in 2018, people said that there is Facebook land because Mark Zuckerberg always had the power to decide alone and himself alone, so no one else. So the governance power is basically their work. So the governance is really belongs to him. And last but not least, sovereignty. And if you check Facebook Horizon, which is like a word, if you read the book of Dave Eggers, The Circle, or you watch the movie Ready Player One, really, you have a virtual world, a virtual reality where you can enter into. And if you are there, you can do whatever you want. So at home, you're a family father, you're taking care of the family and the kids. And when you enter into Horizon, you can be a pilot. Alone and, I don't know, seeking adrenaline everywhere. You can be like really doing drug trafficking online. So you can do whatever you want in Facebook Horizon. And because they both Oculus VR company, the only way how you can enter into Horizon if you build the Oculus. So there is the sovereignty, because of course they said sovereignty belongs to states only, because it is something you have a normative power in a territory which only belongs to you. Horizon is no different. Facebook has full power there, and no one else is going to really interfere with the progress. And why it is dangerous? Last week, an avatar via the Oculus VR entered into the Facebook Horizon, and it was a woman avatar, so a female one, and she was raped online by other male avatars in 60 seconds. Yes, you heard me right, 60 seconds. And she was raped, and screenshots were made, and the woman, the user, was shocked what they're doing. And a week later now, you have like personal boundaries, which keeps avatars away from each other in order to avoid that. But this is just one bad thing that happened there. So I think Facebook is really building a digital state because they have the government, they have the policy-making body, and Facebook Oversight Board, as I said at the beginning, it was compared to the Supreme Court of the United States. So the initial purpose of that is to having a so-called judicial body. So that's all. I hope I would be in the time frame. I tried to check not to be longer than 45 minutes. And thank you very much for inviting. Thank you for listening. I hope that you could really follow me, and there was no language barrier, and I could explain really my thoughts to you. And I'm open to discussion, to any questions, and I'm really glad to be here. And thank you very much.
Thank you very much, Dr. Tamas. I think you've given us a lot to think about. I think the idea of digital state that you bring up, I think that opens up certain very interesting areas of conversations. And otherwise also, I think your talk has been very illuminating in just highlighting the cases itself that that the Oversight Board has dealt with. I mean, there's one member from India, Sudhir Krishnaswamy, on the board. So we've read a couple of interviews of him, and I think some of the concerns really deal with, primarily concerns dealing with the jurisdiction of such an oversight committee, right? And I think you've touched upon some of those issues. I have a couple of questions of my own, but before that, I'd like to ask a few questions that have been put in the chat box. A colleague here, Professor Sukrit Garg, who teaches constitutional law himself, has a couple of questions for you. He says, he's asking, what are the standards of assessment that the Oversight Board uses for its adjudication/review process? Do they have a pre-existing charter of standards that bind them, or they can also decide on the basis of various human rights norms available in international and domestic jurisdiction? I think you've touched upon ICCPR, but if there are any other standards.
Yeah, it's a very good question. Thank you very much. At the beginning, they have the charter and the bylaws, which is like a detailed policy, but the factors which they should be analyzed, it was not included. So basically at the beginning, they said they have a human rights responsibility, and they cited, since the first decision in the Burmese one, the UNGPs, the UN Special Reporters on Freedom of Expression reports, and the Rabat plan, action plan, and the ICCPR standards. So that was which really cited from the first and all of the cases by the board itself. And then they, I don't know which hate speech case, I'm sorry, maybe in the Armenian one or in the blackface, they try to establish factors based upon they accept cases for review. But most of them are made and established by themselves in their case law. So they try to rely on international law, human rights law standards. But as far as I saw, they really try to build upon the ICCPR and the UNGP. So that's what they say, okay, this is the foundation. And we try to, like, I don't know, like swipe everything or flush it under this bridge. And this is our golden rule, because no one is going to say that it is it isn't a good law or something like that. So as far as I can see, they figure out themselves what they would like to apply or not. And since it is just a company's body so far, they can do it. And the UN promotes such an idea because they said, oh yeah, you're voluntarily taking human rights responsibility, so you are very kind. Of course, we know that social media platforms, especially Facebook, is a profit-oriented company. So they are not acting in good faith all the time. They're acting in good profit. I'm sorry for the sake, of course, I'm not saying that they are not feeling responsibility, but I'm saying that the basic of having a company and establish a company is to earn money. That's, I mean, number one rule in company law.
And question just quickly on that. I mean, you mentioned digital state, and this is something that comes to my mind straight away. Then what happens in countries that have not ratified these conventions? I mean, does the Facebook then get the legitimacy to continue in those countries, or does the Facebook get to create its digital state in? I mean, I think a quick Google search told me that a country like UAE has not ratified or nor even is a signatory to these conventions. So what happens in that situation?
I mean, that's a very good point. Honestly, I don't think so far that Facebook and Oversight Board cares whether you have a ratified ICCPR or not. If you enter in, so they said, when you register, you accept our terms. Since you accept our terms, it includes that you have a right to have an appeal against the removed content, within the system, and then you can appeal to the oversight board. We give you that right, and our oversight board has their own decision-making process, which is based upon the ICCPR. So if you don't want that, don't use our service, don't appeal. So I think so far, this is their standpoint. What would really happen afterwards? I think it's a more important question, because I think digital state, what they are doing is in the online environment. And what is my idea, but really maybe I'm too far, that they don't really care about the laws of the offline world. They're building a new world without the offline world's rules and making their own state with their own rules and with their own policies. And I think that the ratification of ICCPR is really not their concern in practice, I would say. Of course, if someone would be here from Facebook, probably they would deny that and say that it's not true and I misunderstood something. But as far as I can see from the research and from the case law and how they decide the case and which are the foundations of the human rights responsibility decisions, I would say that that is the situation right now as we speak.
Okay, I'll ask a couple of more quick questions. I think we're running out of time. So there's another question by my colleague only. He says a few questions. It's a comment / question. A few questions based on observation made in the initial portion of the lecture that bodies like Oversight Board cannot be taken to be judicial bodies. At best, they could be quasi-judicial. Will the ideas of sovereignty or state citizenship be capable of answering concerns of our increased ability to interact? This is part A of the question. Part B is, what role could a comparative lawyer play in such a scenario?
Well, these are very good questions. And if I want to be really honest, I should answer that I don't know at the first one, whether they can tackle and the general standards, how we understand it's great, is whether they're going to work or not. If you really think and go back to the history, there was a peace treaty in Westphalia in Europe in, I think in 1647, something like that.
Yeah.
And it was the beginning when it said we have the understand of the state and what are the elements of being a state. And if we go back further, like ancient Egypt or even like the Indian history, then you would realize that there were like 4,000 years before when we don't really care about these. So I think that the standards we have now in modern democracies, we take them as granted. And we can only think in that framework. We are closed in a box of rule of law and democracy and understanding these elements. And I'm not sure that they can be applied into a digital world. Like if you watch the Ready Player One movie, I know it's just a movie, but really it tries to explain that we have rules outside of the online environment and we have one inside, and they not necessarily need to overlap each other. And I think that's the point. That's why we need fresh eyes, and that's why we need to think outside of the box, because lawyers are always trying to stick to their rules, and it's good. We need stable legal system to avoid anarchy. I agree with that, but we might need a different perspective as well. And what comparative lawyer can do, I think, talk as much as they can and try to understand the IT sector, try to understand the technical background, try to understand the virtual reality and translate it into the language of law and not only to your legal system. So far I checked Germany, USA, and Hungary, but I'm in that research, so I try to continue. And we need to understand what solutions already made in the world, and at least to understand, to discuss and help each other, because I think law is like a reactive science. So anything that happened in the society, we try to make a decision on it, or try to establish a law policy to avoid further actions which we would like to avoid. And in this case, we are in a severe disadvantaged position, because I think when we are going to react with the tools of law, it might be too late.
Like one final question, Dr. Tamas, from my side. Listening to your presentation, there was one very interesting thing that I felt, which is the minority opinions in a couple of cases that you mentioned, in terms of judging whether a speech amounts to hate speech or not, does not amount to hate speech. I think you mentioned something on the lines that in deciding whether a case is hate speech or not, you really have to consider the fact you have to promote the minority opinion. Something on those lines you said, that you have to promote the minority opinion. I think in the blackface case, you mentioned that. That sounds very interesting because, generally in freedom of speech cases.
Sorry, Kusha, I was frozen.
Sorry. So I'll repeat my question. Can you hear me now?
Thank you. Yes.
Yeah. So I was saying that in your presentation, I think in the blackface case, you mentioned that in deciding whether the case amounted to freedom of speech or violation or not, or hate speech or not, one of the criteria that was discussed in the oversight board was that the minority opinion needs to be promoted, or the minority side needs to be promoted. Something on those lines you said. Can you hear me?
Yes, sir.
Yeah, which sounds very interesting because at least in the Indian context, whenever you discuss the hate speech cases, the argument of the other side is that if you have a freedom of speech, we equally have freedom of speech to express our voices. So in that sense, promoting the minority side, or recognizing that there is a historical injustice that makes a certain speech problematic or hate speech, that is something very interesting that comes out in the decisions of the oversight board, right? So what are your opinions on that?
Yeah, I mean, I think it's a very wise decision by the oversight board, that they said that they focused on the historical perspective of the given minority, or the concerned minority, and they said that the reason why this speech must be treated a bit differently is because they were like systematically disadvantaged throughout the history of the country. And I think it also happened in the European Court of Human Rights case law, when, for example, a Hungarian policeman had a case regarding whether policemen, after the regime change in 1990 from the socialism to democracy, then whether they can be members of the parties. And the European Court of Human Rights said that no, because in the previous history, the last 50 or 60 years of Hungary, if you're a policeman and a member of the party, that you are the hand of oppression. And that's the reason why you cannot be that. In another country, they might allow it, but in case of Hungary, due to this purpose, not. And I think that this is what happens in the oversight board decision as well, that not because the Zwarte Piet or the blackfacing would be so bad, for example, in Hungary, when we don't have a history of slavery, and it is not so affected in Hungary. I think if it would be a Hungarian post, of course, it isn't a community value. So they would say that, yes, it's blackfacing, so we remove the content. But the argument would be very different, very different. So I think that it is a good thing.
Yeah. No, it's interesting because I think, at least in the Indian context, we're still struggling to make that argument heard, or, be accepted at large. So that's something that struck me while you were presenting. Right. So I think we have exceeded our time. There are some couple more questions, but I'd like to close here. Thank you very much, Dr. Tamas Pongo. I think your presentation is, I think it's come at the right time. It has, because the social media and the social, or the digital world, as you call it, has raised some very interesting questions with regard to not just freedom of speech, but other human rights as well. And I think there is only going to be more progress in that field. So thank you very much. Before we close, I'd like to invite Dr. Madhuri Parikh, our Dean and Director, to say a few words. Madhuri ma'am?
Until she's joining. I would like to say that if there are unanswered questions, if you can collect them or send me email, then I'm happy to answer it via email.
Sure, I'll do that.
And also my email address can be published, and they can write me directly who have questions, and I'm happy to write, or even we can discuss in video conference. So I'm open to anything if there are unanswered questions.
Sure. Thank you very much. I think Madhuri ma'am has not joined, so perhaps we could just, yeah, she's there. Ma'am, if you would like to say a few words.
No, I was enjoying the session, but just because of some visitors and all, I'll just have to keep my video on switch off mode for a time being. I'm so sorry for that, but it's a lovely session, and I think very interactive also, looking to the questions, and it's the most debated topic nowadays. So thank you so much for being with us and sharing this with us. Our students will be really benefited by this discussion. Thank you so much.
Thank you very much for having me. It was a great pleasure and honor, and I hope we can continue that. I really love to be.
I would like to invite you when with the you can say on the campus only when the situation will be good. So
yeah,
we'd like to meet in the old world.
Yeah,
as well.
we'd like to meet on the campus.
Thank you very much.
Thank you so much.
Thank you.
Thank you.
Thank you.
Bye-bye.
Bye.